Hello and welcome to our virtual pupillage open evening. We are delighted to introduce ourselves and our chambers, 42 Bedford Road, to you. You are going to be hearing from some barristers who will introduce you to some of our key practice areas. And then you're going to hear from a junior member of chambers about what it's like to have a mixed junior practice. Then you're going to hear from a recent pupil about her experience of pupillage, and finally from one of our clerks, and then from our head of pupillage. If you have any questions at any point, please go ahead and type them into the Q&A box. We'll pick those up at the end of the session. And if it's a question to a particular person that you've heard speaking this evening, you can write that as part of your question. I'm now going to pass you on to Eleanor.
Hi, my name's Eleanor Berthelsen. I am a family law practitioner at 42 Bedford Row. I'm going to talk to you a little bit about what family law is and reasons why you might want to do it, and also give you some idea of what my day-to-day life looks like. So family law is something that some of you may not have studied. I'd only done a family law option in the bar course before I decided that it was something that I wanted to practice in, and I then applied for specialist family law pupillages. So please don't be put off in applying for it if your actual experience of academic family law is relatively limited. You certainly wouldn't be on your own in applying to a mixed set where family law was part of your diet. There are three broad areas of family law, and all of them deal with disputes which are interrelationship disputes or disputes which are to do in respect of your children. And they're divided up into three broad areas of private law, which is disputes between parents or carers who are unable to agree on arrangements or decisions regarding their children, or where one person alleges that the other's been abusive to them. Public law, which is where the state intervenes because it is said that children are at risk of significant harm by reason of the care given to them. So that could be their parents mistreating them in some way, or in some other way being vulnerable, for example, if they have abusive relationships or substance misuse problems or something else like that nature. Financial remedies cases is the third major practice area. So that's disputes surrounding the financial consequences of relationship breakdown. Why might you want to do it? Family law, I mean, I love it. I think it's great. It's a very advocacy heavy and fact heavy area of law. So you can expect to be in court most days. So if standing on your feet, representing people, cross-examining is your idea of a great day out, then family law is something you should very seriously consider doing. It's something which you might like to do if you find people and relationships interesting. There's plenty of scope requiring quite a lot of knowledge in other disciplines. So, for example, technical medical knowledge arising from the use of experts in public law cases, for example. You're often dealing with people who are vulnerable for a variety of reasons. So either because they have traumatic early life experiences or cognitive difficulties, or because they're in abusive relationships. So I've just made really catastrophic life choices for some other reason. Generally speaking, there's quite a good atmosphere between family lawyers, probably because we're at court and against each other all the time. And I can't imagine what a day would be like if somebody was seriously unpleasant to me on a day-to-day basis. So people are quite nice. That's not to say that we always agree with one another. That would probably make you quite a bad lawyer. But people are quite pleasant to each other, and then you go into court and you can tear chunks out of each other, and it's quite good fun. So there's lots of scope within family law for using soft skills. So an ability to get on with other people and find common ground can be quite important. Good negotiation skills, good communication skills. It's particularly important because our clients are often very vulnerable and incredibly stressed when they're at court, because the decisions that courts make in family law affect you massively in your day-to-day life immediately the moment you return home. So I practice across all three of those main areas. I used to do mostly care, and I'm probably about 70% children, and that's a mixture of private and public, and about 30% finance. A lot of people specialise. Personally, I quite enjoy the variety, and that's something that I'm able to sustain in these chambers. As a pupil, you can expect to gain experience across those different areas, but that's something which Katrin, who is one of our newest tenants and has just finished being a pupil, will be able to explain a bit more about in a moment. So what does a day in my life look like? It varies quite a lot from week to week, but I'm normally in court 2 or 3 days a week at the very least, if not 4 days. If it's a multi-day trial, then I'll be there, potentially 5 days that week and the week after that. There are some weeks where I might have a couple of days to prepare, other weeks where it seems that I have nothing but conferences and maybe 2 days in court. But court is a feature of every single week that I have been at the bar. Most of my hearings take place in person, so it does involve travel both within London and also outside of London, the South Eastern and the Midland circuits. I personally find it quite exciting going somewhere where I've never been to before, meeting different advocates and appearing in front of different tribunals. Why might you want to do this at 42 Bedford Row? Certainly what I found, because I haven't always been here, is that it's very appealing to me. It's a highly motivated practice group. It's also very supportive, which is incredibly important as you are a self-employed person. There are always people asking each other questions on the WhatsApp groups or picking up the phone, and I probably answer at least a couple of calls a week from junior tenants who are asking about points which have arisen in their case, or just to be used as a sounding board, and I will also do that myself. So it's incredibly important, not least because this is a job where you learn a lot by osmosis, and I'm going to go on to my top tip for being in pupillage, which is really to allow yourself to be inquisitive, ask lots of questions, whether it's about the law or aspects of practice. Listen to the people around you, listening to them talking about their cases, because you'll accumulate knowledge without even realising it and find a ready application in your day-to-day practice. So those are my tips for pupillage and family law, and I'm going to pass you on to Iris, who's going to be talking to you about housing.
Thank you, Eleanor. My name is Iris Ferber, and I am a housing law specialist here at 42 Bedford Row. What is housing law? Well, have you ever lived somewhere that was rented, maybe by your parents, and there was a landlord? Or maybe you've rented a flat with your mates or with a boyfriend or girlfriend. Well, if you have, then you already know something about housing law. Housing law is the law that governs the relationship between landlords and tenants. It's about the rights and the obligations on both sides of that relationship. Some of those rights are contractual. They depend on what it says in a written tenancy agreement, which most tenancies have. Some of the rights and obligations are statutory. They are dictated by the contents of the Housing Act 1985, if the landlord is a local council, or by the Housing Act 1988, if the landlord is either a housing association or a private landlord. And there is also extensive rights and obligations in the Equality Act as well that relate to the letting of premises. And if the landlord is a local council or a big housing association, then some of the rights and obligations are a matter of public law as well, just like judicial review. So it is an area of law where if you are a housing barrister like me, you get the best of all worlds. I get to argue my cases in the county court. I get to argue my cases in the High Court. My cases involve contract law, statute law, discrimination law, and public law. Sometimes my cases are about breaches of tenancy, like perhaps the antisocial behaviour of a tenant, or my cases might be about disrepair that is not fixed by the landlord when it should have been. And those sorts of cases often involve applications for injunctions or applications alleging a breach of an existing injunction. Those are particularly serious because they can end up with the tenant or somebody in their family who has been behaving badly being sent to prison. Most often, my cases are about whether a tenant should be evicted from their home. And we call those possession claims. So what will you be doing in the housing courts as a pupil barrister? Well, you will mainly argue short, straightforward possession hearings. So that's hearings where the court is deciding whether or not to evict someone from their home. You might be representing the tenant, but most often you are going to be, in these chambers, you're going to be representing the landlord. And you'll maybe get 5 minutes, no more than that, about as long as I've been speaking to you just now, to explain to a judge why this tenant should or should not be evicted from their home. You could also end up doing some directions hearings in more complex cases. A directions hearing is a hearing where a timetable is set for preparing a case for trial. You might even, as a pupil in your second 6 months, get to do 1 or 2 hearings involving antisocial behaviour injunctions, which I've talked a little bit about already. If you do end up doing any antisocial behaviour injunction cases during your second 6 of pupillage, you can look forward to a very rare thing in the civil courts, especially for junior barristers, what my pupil supervisor used to call putting on the Batman outfit. That is, you get to wear your wig and gown in court. And outside of a housing case, and outside of criminal cases, that is a very rare thing indeed. So now that you know a little bit more about housing law, let me give you my pupillage tip. Always make sure that you are on time. There is so much in life you cannot control. One thing you can control is planning ahead and turning up on time. Thank you. The very best of luck with your pupillage applications, and I'm now going to pass you on to Peter.
Good evening, everybody, and it's excellent to see that so many of you have been able to join us tonight. My name is Peter Jolly, and I'm the member of Chambers in charge of our business and property group. So let me tell you what business and property is all about to start with. We're a very broad group in Chambers, and so we cover work to do with commercial law and also real property law. The group is so broad that as you become more experienced as a barrister, it's very unlikely that you would cover everything that the practitioners in the group do. So, for instance, I specialise in property work. I also, as it happens, do a little bit of housing law as well. What then does the property work tend to involve? Well, it's not social housing in the sense that Iris has already described. It's property work which would typically fall under things you might be asked to think about are the covenants under somebody's lease, the rights that someone may have over a residential property or a commercial property, rights to light, for instance, or rights of way, issues to do with the land register, and for instance, if rectification of the register may be needed. Practitioners in the group also deal with matters surrounding the purchase and sale of properties, also how they're built, and how sometimes they're also demolished. And relevant things which arise are questions of fraud, misrepresentation, and problems that also happen with the buildings themselves. For instance, when a commercial property falls into disrepair, so commercial dilapidations disputes. Other members of the group also deal with issues surrounding trusts, wills, and probate. And then there's the business aspect of the work that members of business and property are also specialising in. Work in the commercial sphere would involve insolvency work, proceedings against directors, cases which involve questions arising under the Companies Act 2006, and also matters of general contract too. So what, for example, does a contract actually mean? What are the remedies that should be pursued if the contract is breached? So that gives you a flavour, I hope, of what the work within the group is like in general terms. Let me tell you next about what the work at the junior end is like if you were to undertake pupillage at 42 Bedford Row. I was thinking back to when I was a pupil. I've always been at 42 Bedford Row. I was asked quite early on to advise in relation to a wiring problem in a very expensive high-end car, and what possible remedies might be sought in relation to getting that issue sorted out. I was also asked to advise in a case where a lease over a commercial garage had come to an end, and the question was whether it had been validly ended, and if that wasn't the case, what might be done about it. I also went to court as a pupil quite a lot, often in relation to possession work, and naturally there's some overlap with housing, but as I mentioned earlier, not social housing cases as such. So that's something that you would probably expect to see quite a lot of as a pupil. And also the types of hearings that Iris has also mentioned, such as directions hearings, setting a timetable for a trial, in other words, and applications that can arise in cases. Sometimes a judgment may need to be set aside, for instance, and that's the sort of thing you might be asked to do in going to court. Or you may have the pleasure of baptism by fire, by being asked to go to the commercial court in the winding up list in relation to a company matter. So the range of work that you would see both as a pupil and as you become more experienced as a practitioner can be quite broad. But as I mentioned at the start, over time, you're likely to specialise as you go along and do more of a small number of things rather than the whole range of work that the group undertakes. Let me give you a tip for pupillage, just as Eleanor and Iris have also done. My tip would be to be yourself. And pupillage can be a stressful time. Naturally, you are anxious as a pupil to make sure that you're doing everything that's required to the best of your ability. But being a barrister can be quite a lonely existence, and we spend a lot of our time with our heads in our own cases. And you'll find that barristers, when they get together, like to socialise and spend time talking about cases. And it's important as a pupil that you also feel that you're able to do that and you express a little bit of who you are and, as I say, be yourself. And that's just as important, I think, when it comes to completing a pupillage application. And please don't be afraid when it comes to completing an application to tell us what your interests are and what else you like to do besides reading the white book. So that's my tip for pupillage, be yourself. I hope that's been helpful in terms of what the Business and Property Group in Chambers is all about. And I'm going to hand on next to Rebecca Thomas, who's going to tell you a little bit about employment work.
Thank you, Peter. Welcome, everyone. Yes, so my name is Rebecca Thomas. I am an employment specialist. In fact, I'm head of the employment team at 42 Bedford Row. And these days, having had a general civil practice, employment is all I do. So what do you need to know about employment in general and employment at 42? The first thing to tell you is that we have a very large and specialist group in Chambers. It is extremely well regarded and is ranked in the directories as a group. I think most people think they know a bit about employment and employment law because employment is such a fundamentally important part of so many people's lives. In our chambers, the work we do is primarily tribunal work, disputes between employers and employees, although you may find yourself dealing with some matters in the High Court, particularly to do with contractual matters such as restrictive covenants or perhaps more highly paid individuals. The type of work that is undertaken in the employment tribunal relates quite often to the loss of employment, so unfair dismissal, but it also deals with matters such as discrimination and the Equality Act. So I'm sure you will have heard of the various protected characteristics there are under the Act, such as sex and race, and they are frequently played out in the employment tribunal. As a Chambers, we do both employer and employee work, so we do act for both sides. But I think it's fair to say that the majority of the work we undertake in Chambers is for employers or respondents. The reason for that, quite simply, is that there's very little funding for the legal costs of employment work. There's nothing like legal aid available. So quite often claimants cannot afford representation, and it's the employers that pay a lawyer, which is where we come along. In your early time at 42 in the employment team, you could expect to find yourself in the tribunal, hopefully on a fairly regular basis, and you would be dealing with quite small matters. So as Iris mentioned, directions hearings, which are called preliminary hearings or case management in the tribunal, where you work out the legal issues in the case and decide the timetable for how it's going to come to that final hearing. You could be expected to be going along to those, and as you progress slowly, to deal with smaller hearings, maybe a half-day or one-day hearing. Employment law is a brilliant way to build up a practice, because you can start with those smaller cases and just get bigger and bigger until you get to the grand old call that I am, and you find yourself doing 3 or 4 week trials of very complex and multi-day hearings. And it's a really good area of law, because if you want to be a barrister, you probably want to be an advocate. And employment law is that brilliant mix of interesting intellectual arguments and complex law, and loads of cross-examination and advocacy in the employment tribunal. And that's why I really enjoy it. And I think that's why it's a good option to take. If you do come and do pupillage at 42, we tend to move the pupils around. So there's a pretty good chance that you would spend some of your time with a pupil supervisor who is an employment specialist. We're also a big and friendly team and provide lots of support to our junior employment lawyers. We do regular training and seminars, and we, as far as possible, go out and meet our clients, which can be a great opportunity for you to meet them and obtain some work. So that's just a quick snapshot of what employment at 42 looks like. Like everyone else, I've got a top tip for you. My top tip is perhaps more specifically about the pupillage application itself. In the form, you'll be asked to give examples of work experience that you may have obtained. If you've been on a mini pupillage or perhaps attended a court hearing, don't just say that you've done that. Give us a bit of information. Tell us what you saw, and tell us, importantly, what you learnt from it. This will show us that it was a valuable experience for you, that you've reflected upon it and taken something away from. So on that note, I'm going to hand over to Eleanor.
Hi everyone, I'm Eleanor Wheeler. I'm going to talk to you about PI and ClinNeg. They are two separate areas of law, but at 42 they're dealt with under one group, and there's a lot of interlinking between the two. I'll deal with personal injury first of all. We tend as chambers to act for both claimants and defendants in these type of cases. And personal injury is such a broad area of law. It ranges on one hand from what is not so affectionately known as ambulance chasing. I promise that's not what we actually do, but that would be the types of injuries where people have fallen over in a public place or have sustained an injury because of a building that's owned by a company or individuals. We also deal with road traffic accidents and injuries arising from those. We deal with employers' liability cases as well, so where someone's been injured in an accident while at work. That encompasses a lot of different factual patterns, but I think the key thing that ties them all together is similar to certain other areas within chambers. It's a lot of advocacy. So whether you're right at the junior end or more senior, you can expect to be in court a lot, which I love and lots of people do. We do a lot of work through unions, but largely for claimants in those cases. So we will be preparing cases against big companies like Heathrow and British Airways, where people have sustained injury while at work. And we also deal, as I say, with quite a lot of road traffic accidents. I think one aspect that a lot of our pupils tend to do a lot of work in is the small claims court, and small claims can encompass all sorts of different types of claims. but the most common one is road traffic accidents, and the feed on from a simple road traffic accident is an accident where someone's hurt themselves, and that's when you get into the realm of PI. The higher end of personal injury work is tends to have a lot more involvement from experts. They can range from medical experts to forensic engineers, and some more obscure expert fields like arboristics and all sorts. You tend to do more written work at the higher end, and a lot more of these hearings, much like other areas of law, where you set directions through to trial and set budgets for each party's solicitors to work to. If you were going to start off at the junior end, you're probably looking at shorter hearings lasting a couple of hours up to a day, and then it runs all the way through to the more senior end of chambers where people are doing multi-day trials. It's a really varied area of law, and I would encourage any of you who would like to do a broad civil practice to give it a go, because it just includes so many different areas, and you'll meet so many interesting people. The other area of law that I'd like to talk to you about is clinical negligence. It's similar to personal injury in the sense that it involves people who have been injured through negligence, but this time it's either directed at doctors or nurses or dentists, orthopods, we've got chiropractors, all sorts of different treating professionals are encompassed. We as a Chambers mostly do work for claimants in that scenario. The NHS is represented by one specific body, and they tend to have specific lawyers that they instruct. So we do a lot of claimant work, and what's really interesting about clinical negligence is that it's almost entirely expert-led. So we rely on medical experts to tell us what's gone wrong in a case, what that has led to, and what the likely consequences for a claimant are going to be. What I love about that is every day, most days, you are talking to nationally renowned experts in their fields and getting their view on really interesting medical topics that you would never ever come across in any other area of law, and getting really stuck into those as a matter of course. It's fair to say that there is less trial work. Most clinical negligence matters settle because the experts can either agree on everything and it goes away, or they don't agree on certain issues, but you can reach a settlement based on the risks relating to those issues. So a typical day in a clinical negligence world would be conferences with experts, conferences with your client, drafting schedules, drafting pleadings, and attending settlement meetings. There's less court work, but most people in Chambers do a balance of personal injury and clinical negligence, and then you get a really good mix of advocacy-based work and written-based work. Overarching both of those is always a sort of undercurrent that flows through both areas of law are the tactical issues, really. So when to put offers, and this isn't something that just applies to personal injury or clinical negligence. We all as barristers deal with this every day, but you find particularly in clinical negligence cases that timing of offers and when to decide or to discuss settlement can make or break a case. So it's a very tactically led area of law as well, which I find quite interesting, and I know some others do too. So hopefully that gives you a fairly good overview of what the work in those teams is like. I'll give you my tip for pupillage. It's a practical one. It's got lots of limbs, but effectively the name of the game is just be really organised. It sounds easy, but pupillage can be very hectic. There are lots of unknowns. as Peter said. And one of the things that you can do to guard yourself against a sense of anxiety is just to make sure that you're on the ball. And this is something that my pupillage supervisor told me, and I've always done it, and it works. Always get the train before the one that you absolutely need. Always print your papers off the night before. The printers seem to know that you're in a rush and will just do anything they can to thwart getting your papers out in a helpful way. If you are traveling to court, look up where it is the night before so you know what your journey looks like. Check who your judge is the night before. There's a really helpful website on the judiciary.gov.uk website, has a section called "What do I call the judge?" And I cannot tell you how many times I've panicked, checked the website because I was in front of a new type of judge, whether that's a recorder or a circuit judge, a magistrate or a district judge, just to check how I address them, both when I'm in court and via email. Takes the stress out of it so that you don't stand up and think, oh my goodness, I don't know what to call the judge the minute you have to start speaking. So I think those would be my tips. Be organised and you should be absolutely fine. I'm going to pass over now to Andrew to give you some hints and tips about life as a junior in Chambers, and also tips for pupillage as well.
Thanks, Eleanor. My name's Andrew Carter, and I'm one of the barristers at 42, and I have a mixed practice. And it spans most of the areas of practice at 42. So I act in business and property, I act in landlord and tenant work, I do employment, I do family as well, in all three areas of family, so private disputes between parents or carers, care cases which involve this, and also money cases in family. So I have a very, very broad practice. Probably broader than most. And what I really enjoy about 42 is that there's the space to pursue that. And of course, from what I have found is that having a mixed practice has really contributed to my development as a barrister and as a lawyer, because the various different areas of law invariably have different ways of thinking about things, or at least expressing the way that they think about legal issues in the judgments. And what I've found is that there's no hierarchy. It's not all that all the insolvency judges know exactly the best. It's not that the employment lawyers are the best, but reading cases across all the areas of law is incredibly valuable. So what does life with a mixed practice look like? Well, this week on Monday, I was in before a master in the High Court on a commercial property dispute that went south. And then I was drafting a response in the valuation tribunal in a property matter. Then I was dealing with an employment particulars of claim. And then today, I'm up in Oxford today after a day in court dealing with a private law contract dispute. Literally every week tends to be different. It tends to go in ebbs and flows with different practice areas. So there might be times where it's strongly employment and then strongly family. But you just end up rolling with it as it comes. I think one of the other benefits from having a mixed set is that you're always busy, which, if you're anything like me, is a good thing because it keeps me calm. It keeps me calm that I'm busy. It's much better to be busy than quiet when you're self-employed. So I really enjoy it. One of the questions that I've seen that's come through is about the pressure to specialise. My perspective is that I haven't really felt any pressure to specialise. I've been at Chambers for about 2 years now, and there hasn't been any serious pressure to narrow down my practice. But what tends to happen is that you find what you like, and you find that your diary is so full that you can't do and pursue those things that you like. So you end up editing down your practice. And so recently I have done that with respect to my PI practice, because that wasn't suiting me anymore. And I've got a practice meeting happening this week where probably a little bit more of that will happen. But I really enjoy a mixed practice. As I say, it keeps me on my toes, it keeps my research skills sharp, and requires me to think in different ways. It's of course, if you're in a family dispute about children, issues of welfare require sensitivity and creativity, I think, with respect to the facts. And if you're dealing with an easement problem, then what you need to do is make sure that you know what the rules are, so that you can properly advise the client about which side of the rule their facts fall on. Turning to my top tip about pupillage, for me, it's that the most valuable thing that all barristers have is their ethics. And ethics, in my view, is broader than the standards of, don't mislead people and don't mislead the court and so on. It's also about being courteous and respectful to your fellow practitioners and to the court, and it's also about being prepared and ensuring that the court is going to be assisted to the extent that you are able to assist the court to get the right result, because that's the overriding objective of the administration of justice. I also find that ethics is the foundation of good advocacy, and there's nothing less persuasive than someone who looks like they're trying to pull the wool over your eyes. So that would be my top tip. And as I say, life as a mixed junior is fantastic, really, at 42. I'll now hand over to Catherine Howells, who's recently joined as a tenant from pupillage.
Thank you. Yes, my name is Catherine. I did pupillage at 42. I started in October 2021, and then I started as a tenant in October this year. So I've been a tenant for about a month and a half. I'm going to be talking a little bit about daily life as a pupil at 42 and the transition into tenancy. So you might know that pupillage is split into 2 6-month periods. Your first 6 months is spent shadowing your pupil supervisor or supervisors. And then your second 6, you're on your feet, you're undertaking your own cases. So for me, my first 3 months was spent doing family work, and I was shadowing predominantly care work. At the time, a lot of the cases were still remote, but having spoken to one of our pupils today, there seems to have been much more of a shift now back into more in-person hearings. In my first 3 months at 42, I was in court every day, basically on cases, sometimes 2 hearings in a day. I would also be attending pre-hearing discussions with my supervisor and also advocates meetings. The types of hearings that I would be shadowing would be short interim care order hearings, case management hearings, but I was also shadowing multi-day fact findings and final hearings in care proceedings. For those hearings that I'd be shadowing with my supervisor, I would receive everything that my supervisor would receive, and that would allow me to read into matters. And I found that this is really helpful to help you develop your own methods of preparing cases, getting to grips with papers at short notice. It's a very individual thing. I think that probably everybody here prepares their cases in different ways and has their own ways of getting to grips with lots of information in a short period of time. Whilst shadowing those family cases, I'd be asked to undertake specific tasks as part of preparing for a case. That could involve making notes for cross-examination of a specific witness. I recall preparing a cross-examination of a vulnerable witness in a family case, or it might be drafting a position statement or an order following a hearing. I'd then have time with my supervisor after the hearing, after having seen how they've done that element of the case, and we'd have a chat about the differences between how I'd prepared and how they prepared, and I'd received some feedback. After Christmas, so I was into my second 3 months, I was shadowing civil work, and I had supervisors in personal injury, employment and housing. My work in the second 3 months was slightly less court-based, but I would say I was still in court at least 3 or 4 days per week. I was attending court on multi-day employment tribunal cases and housing cases. I also attended joint settlement meetings and conferences on personal injury cases. One of my supervisors was sitting as an assistant coroner, so I also shadowed him in the coroner's court and attending an inquest. In terms of tasks that I was asked to do for my second 3 months, it was similar to as when I was shadowing in family. So I was asked to do cross-examination of witnesses, legal research, preparing closing submissions, and it would be a similar process with receiving feedback from supervisors. Towards the end of my first 6, Chambers and the clerks kindly arranged for me to shadow some junior tenants for 2 weeks to have a better perspective on the types of cases that I would be doing when I was on my feet. Whilst of course my supervisors were incredibly helpful and I learned so much from them, they were doing very complex cases, or at least more complex cases than I would be doing when I first got on my feet. So that period of time really helped me to get to grips with the type of work that I would be doing when I was on my feet. So now we're moving into my second 6. I'd say that I was eased into it. I had around 2 or 3 cases a week at first, and this soon increased to being in court 4 or 5 times a week, which I would say is typical. I found that the beauty of the very beginning of second 6 was that if I found something came out of my diary last minute, then, or if I had a day or 2 in between cases, I could shadow my supervisor or another junior member of Chambers, which was again a really great learning opportunity. Just to give a flavour of the types of hearings that I was doing in my second 6, I recall doing small claims trials for road traffic accidents, as was mentioned by Eleanor earlier. I was also doing lots of different types of hearings to do with private children matters, so that's disputes between parents. That included first hearings, directions hearings, and also short final hearings. I was also doing some financial remedies work, some small financial remedies work, whether it be fewer assets. I was doing first hearings and also financial dispute resolution. I did a 1-day trial in the employment tribunal, and that was for an unfair dismissal matter. I was also in court doing applications hearings in civil matters such as relief from sanctions. It was really varied. My practice was varied and still is. I've had a little look back in my diary, and I can honestly say that no 2 weeks were the same, and that has continued into tenancy. I'd also say that although in your second 6 you're appearing in court under your own name and you're on your own at court theoretically, my supervisor was always contactable to chat through any issues I'd come across. And there's also great support within Chambers through the junior members, and also my previous supervisors were always at the end of the phone. Moving on to my pupillage tip. My tip is just to make the most of your first 6. And the aim of your first 6 is to be a sponge and to absorb as much as possible from your supervisors. It's a great opportunity to be asking questions and getting feedback, which you won't have the opportunity to get as often in the practice. I'm now going to hand over to James, who's going to talk about things from the clerk's perspective.
Thank you, Catherine. So I'm James Tignam. I'm the Senior Family Practice Manager here at Chambers. And I'm going to give you a very brief overview of how the Clerk's supports you throughout your pupillage, into tenancy and the first couple of years of practice. So in your first 6, it's probably when you have the least amount of interaction with the Clerk's room, mainly because you're spending time with your pupil supervisors, shadowing cases and spending a lot of time working alongside them. During the first 6 months, though, the Clerk's room will assist with finding appropriate cases, as Catherine's already mentioned, for you to shadow, particularly junior end, so you get a feel for what you're going to be doing when you start your second 6. And there may also be times where you're asked by other members of Chambers whether you can help with researching case law and doing some general research as well. In your second six, as Catherine's also mentioned, it's when you're available for work and on your feet. At 42, we like to have an initial meeting with pupils starting their second six to discuss paces and potential work that you're going to be doing and what you can expect to receive during the second six, so you've got an understanding of what's likely to come your way. In that meeting, we'll also explain good habits around client care and certain chambers procedures that we have, which includes sort of day-to-day clerking and expectations from the clerk's room. There's also discussions about billing processes, and we'll also give you useful information, email addresses, stuff like that, to get you through your second six. During that meeting, we'll also explain client expectations and provide useful information and tips on how to develop excellent client care services and what clients are looking for in you as a barrister. We'll also provide feedback regularly from solicitors and assist you in growing new relationships with people that you'll be working with for the first time. Into tenancy, it's very similar. As Andrew already mentioned, he's got a practice meeting this week. We have regular practice meetings during the first couple of years of your tenancy, just to discuss practice, and the shape of that and the early stages and sort of where you're going. We'll continue to provide feedback from solicitors, discuss that through with you. If there's any issues that arise, we'll work through them together with you and the professional client as well. And in terms of a tip for a successful pupillage, I would say be accessible, responsive and communicative. Communication with your clerks is key. A good line of communication between you both is very important, particularly going into early practice. I'm going to now pass you over to Sophia Farouk, who is going to tell you a bit more about what we're looking for in our applicants.
Thank you, and good evening, everyone. First of all, can I apologise for not being here from the beginning of this session? One of the things about a career at the bar, which you will learn pretty quickly, is first of all, the travel involved, and secondly, the sheer unpredictability of all of that. So today, the trains from Paddington decided to be problematic, and that's just the way life is sometimes, unfortunately, when travel is part of your life. But I'm here to talk to you in my capacity as Head of Pupillage about, first of all, the process of application, and secondly, about the structure of pupillage. I can see that a number of questions have come through already about both of those topics, and hopefully I can answer most, if not all of those in the next few minutes. If there's anything at the end of this that you're still unsure about, then please do ask. And in the meantime, if you have any other questions, particularly about anything that any of our panelists have said, then please do send those through, and we'll see how many we can get through before the end of this session. So in terms of pupillage in Chambers then, some sort of general information, which I know lots of you are interested in. Chambers looks for up to 2 pupils every year. The award for next year is £40,000 per annum, with a guaranteed earnings of £15,000 on top during your second 6. Application process is through the portal, so you'll fill in the application form through there. In terms of what we're looking for, how do I stand out? We've had quite a few questions about that. The really simple answer, although you might be surprised by it, is actually just to make sure that through that form you showcase your strengths, your interests and your skills in a way that is appealing to the reader. Remember, as Chambers, we and many others will be receiving literally hundreds of applications, and we have to sift through those. And what we're doing when we read them is, of course, we're looking for those key things. What are your experiences? What are your academic abilities? But what we're looking for also is what makes you stand out, what makes you interesting, what makes us look at those forms and say, actually, that's somebody who we'd like to interview. And it really isn't as difficult as you might think, because although we do get hundreds of applications, and I read the vast majority of them, there are many that I look at, and actually they might have great grades, but there's nothing particularly interesting about this person that makes me think, actually, I'd like to meet them. So think about what it is that you have done, What experiences do you have? And how can you showcase those to somebody else in a way that makes you sound like the kind of person who they would actually want to meet? Of course, please don't forget the really basic and important things. The most important being check your application and check it again and get 3 other people to check it for you before you actually submit it. I cannot tell you the number of times I have read what I think is an utterly brilliant application, only to get to the last page and see this very, very obvious typo or spelling mistake in there, which just shows that that person hasn't really thoroughly checked it. And the reality is, when there are that many applications, you do need to make sure that you have done all those basic things, like making sure that you haven't missed a spelling mistake in your application form. So do go through it and make sure that you're absolutely clear that it is as perfect as it possibly can be in the circumstances. So in terms then of how we then look at applications, of course, we are assessing applications based on your academic abilities. We are looking at your experiences. We want to make sure that when you complete that form, you can tell us and show us that you understand something about what being a barrister is all about. And that doesn't mean that you've just gone to court. As Rebecca said, tell us what you learnt from that experience. What did you actually perceive? And that really helps us to understand the extent to which you've understood the profession yourself. Then, when we have looked at the application from that point of view, we're also looking at, well, how do your interests align with ours? It's all well and good that you've applied, but if you tell us you want to do criminal work, then you probably applied to the wrong place. So we've had a question in particular about mixed areas of practice, and how do I show that I'm interested in more than one area? Can I show I'm interested in more than one area? And the answer is yes, of course you can. We're not expecting pupils, or prospective pupils, I should say, at that point, to actually know what it is that they want to do. Sometimes you might have a particular experience that has guided you to decide that you want to specialize in a particular area. And if that's the case, then great, tell us and tell us why. But if you don't, that's not a problem either. As you've heard, the first few years of your practice in a set like this are likely to be very varied. And that is not an issue. So please tell us what it is that you're interested in, even if it's a few different areas, and tell us why. What is it about those areas that attracts you? Why do you think you'll be good at those particular areas? Because those are the things that we will be taking into account. So far as the interview process is concerned, we run a 2-stage process. So we will invite a larger group of people to a first round interview. That's a fairly short interview. It's more about getting to know you. We have the piece of paper in which you tell us about yourselves, but we can then put that along with actually getting to meet you and seeing how you come across. And those people who excel in that first round interview will then be invited to round 2. And in the round 2 interview, you will have a question to think about shortly before the interview, which you will then discuss with the panel. We will also ask you some ethical questions and discuss any other areas of pupillage that you're interested in. In terms of the structure of pupillage in Chambers itself, you obviously heard from Catherine in respect of her time in Chambers, and that's pretty standard. So you will probably spend as a pupil around half of your first 6 or around 3 months doing some sort of civil work and so then doing some sort of family work or vice versa. We will, of course, take account of areas that you might be interested in, and we will try and accommodate those where we can. But the aim is for you to get a broad sense of the different work that we do, because that's the best way to prepare you for life as a junior tenant in the way that Andrew described. In your second 6, as you've also heard, you should be spending a fair amount of time in court, but you will, of course, always have the support of your supervisor. And that actually continues even beyond, because we do try and make sure that at the end of that year, you have the opportunities to get to know a wide variety of people in Chambers who you can call upon if you need help at any time. So far as assessment is concerned, we don't make you do any sort of formal advocacy assessment or anything like that. Your assessment is going to be by your supervisors, who will ask you to undertake work for them, to complete written work, to prepare cross-examination, all the things you've already heard about. And you will be provided with feedback on those particular pieces of work in order to help you develop and progress, but also for us to have an insight into how you're doing. I think that pretty much covers most of the questions that we've been asked already, but please do say if there's anything else that you're interested in. We have had a few specific questions, which I'm now going to hand out to the panel, who will then be able to assist. So please do keep those questions coming if you have them. The first question that we have is actually about location. So the question is, where do members tend to live? Is it affordable to travel into work? And is there a requirement to be in the building every day? Perhaps, Andrew, if I ask you to kick off with this one as one of the junior members of Chambers.
Yes, so I live in London. I live in Clapham, and I tend to travel around all over the country, really. So today I'm in Oxford. It's certainly affordable to travel, and at least that's my experience. And there's no expectation that you're in Chambers every day. To the extent that you can get into Chambers to talk with other members about, and just to be around the discussion that other members are having. That's a very helpful thing, as Eleanor pointed out when she was speaking. But I don't find that travel is prohibitively expensive, even travelling around to various courts. It's usually well and truly covered by whatever brief fee. And if it's not, then it's often billed as an expense on top.
So just dealing with the second part of that question then, in terms of expectations of being in the building, as you've heard from James, being, as particularly at the junior end of the profession, being available, being in contact with the clerks is obviously very important. Andrew and Catherine will no doubt tell you that occasionally you will be asked to do things at short notice. So it's really important that you are fairly near or in Chambers during that time. But we don't operate any strict core hours or anything of that nature. It really will depend on the situation, the work that you're doing, and where you are on that particular day. We've had a question, Iris, directly to you. The question is this: I've seen on Chambers' website that you are ranked in both employment and housing law. Is it a lot of pressure having a good practice in two different areas?
Thanks, Sophia. No, it isn't, not for me anyway. I mean, different people are different. I know Rebecca, as you've heard, these days specialises purely in employment law. For me, there is, I find, less pressure in having two areas, purely because it gives me a little bit of variety in my work, and it allows me to deal with discrimination, which is the area of law that interests me the most, in a variety of different circumstances. So that's in an employment context and in a landlord and tenant context. And that's, generally speaking, where my work tends to be in discrimination law. So the answer to that is, it depends on the person. If what you want to do is in due course is two areas of work, then do it. And you can be, as you say, you can see from my profile that you can be ranked and successful in two areas of work. You do not need to specialise only in one area in order to excel at it.
Thanks, Iris. We've had a couple of additional questions in relation to applications, so let me deal with those. First question is, I'm a mature applicant who's had a previous career before training to join the bar. Is this a problem, and what can I do to help my application? Simple answer is absolutely not. We have in this chambers members who had previous careers before coming to this profession. It's not an issue at all. In terms of what you can do to help your application, it's often useful if there's a particular reason that has triggered you to change careers, to choose this career in particular, then tell us what that is. What is it about this profession that made you decide to switch? Because if we have an application where that's not at all clear, it obviously leads to a bit of a question as to what is the motivation of this person to retrain. So I'm sure there must be a reason. Tell us what it is, explain your rationale, explain what you've done to get yourself to that position. And you're not going to be at any disadvantage just because you have had a previous career. In fact, you can use the skills that you have no doubt accumulated in your previous career to support your application and demonstrate why you say that you think that you will excel here. So that's not an issue at all. I think we've had some questions actually about the social side of chambers. Peter, do you want to say something about social events in chambers?
I'd be happy to. We're a very friendly and social set. We have a regular monthly get-together in chambers, which is in the late afternoon. That's to allow anybody who's in chambers on that day or is perhaps travelling back home through London to pop in to meet familiar faces and have a chat about what's been going on. We also have regular parties in each of the groups. Some of those we invite solicitors to, so they're used as opportunities for marketing, not just for socialising in chambers. But people also make their own arrangements. So they might have lunch together on a particular day, or they may get together for other social activities that they decide to organise. And the advantage as well, I think, of being part of a large set such as ours, in which people do lots of different areas of work, is there's always lots of interesting conversations going on, and people want to spend time together and socialise in that way. So as I say, I think we're a very friendly set, and it's commonplace that people do spend time together outside of their casework.
Thanks, Peter. Another question about the application process, which says, I have a lot of experience in family law, which is a chambers practice, but I'm not sure how to evidence that I'm interested in a mixed chambers. So sometimes we will get applicants who, for whatever reason, have a particular interest in one area of law. That doesn't preclude you from applying either. The key thing is that you have to appreciate that we are a mixed set. So you can't come to chambers and just expect to only do one area of work throughout your entire pupillage and your junior career, moving then on forwards. So if you have a particular interest in one area, that's not an issue at all, so long as you also appreciate that you will be doing a wide variety of work, particularly in the first few years. Another question about the application process: is there a space on the application form to explain extenuating circumstances? Yes, there is. So on the form, there is a section towards the end, which is a voluntary section. It's entirely up to you if you want to use it. But if you do have extenuating circumstances, there is a space for you to provide any additional detail that you want to give in relation to that. Thank you for your questions so far. Please keep them coming if you do have any. I'm just going through to see if there are any more that we have missed. We have had lots of general questions about the application process, but hopefully we've covered those already. Although, as I said earlier, if there is anything that you think that we have missed, then please do say. Another question that's come through in relation to applications: does an unsuccessful application previously hinder you in future applications? No, of course not. The inevitable consequence of applying again is that you have another year's worth of life experience, if nothing else, during that period of time. And so inevitably your application will be different. I would hope that if you were to reapply, that would be an application that would then reflect what you'd been doing within that year. And so we will take each application at face value, and you would not be penalised in any way if you had applied before. We've also had a question in relation to mini pupillage and what 42 Bedford Row are looking for. So on our website, there is a section on mini pupillage which sets out the details of how to apply. The process is inevitably slightly different at mini pupillage level, and that is set out within that section on the website. But in very simple terms, what we're looking for is somebody who can demonstrate that they have an interest in the profession. We fully appreciate that at the point that you are applying for a mini pupillage, you're not necessarily going to have a huge level of experience about the profession more generally, or indeed any particular area. That's the whole point, of course, of a mini pupillage. So we are looking for people who can demonstrate that they have clearly an interest in the profession, and that process will then allow you to spend a few days in chambers, seeing some court work, and possibly spending some time in with members of chambers as well. We've also had a question about whether or not it is essential to complete a mini pupillage before applying to chambers, and whether if you had not completed a mini pupillage that would hinder your application. I think in previous years, the simple answer to the question would have been, well, if you haven't done a mini pupillage, that inevitably puts you at a disadvantage, because the reality is it's the best way to actually understand what the career looks like in practice. But we also acknowledge that the last few years have been difficult. It hasn't been easy to obtain mini pupillages, particularly since the pandemic hit. And so we're not necessarily specific about saying you must have completed a mini pupillage. But if you haven't, what we would say is that it's important that you can demonstrate the steps that you have taken to learn more about the profession, and to make clear in your application that you do have some understanding of what life is like as a barrister. Attending sessions like this are of course very helpful for that, but it's important that it's clear to us that you understand what you're applying for and what you're actually getting into. We've had...
Sophia, may I just add?
Of course.
Sorry to interrupt you, but there is a distinction, isn't there, between somebody applying who hasn't done any mini pupillages at all versus somebody who has done mini pupillages but just not here at 42. And those are two very different things. And there'll be plenty of people who apply who haven't done a mini pupillage at 42, but somebody who hasn't done any mini pupillages at all, we would need to be thinking about what it is they have done in order to get themselves familiar with life at the bar.
Yes, absolutely. We don't have, as some chambers do, a requirement that you have to have completed a mini pupillage in our chambers, but it is important that you have an appreciation of what life at the bar looks like. Mini pupillages are, of course, the best way to do that. But as I said, we do acknowledge that things have been difficult over the last few years. So we don't operate a blanket rule that precludes you or your application from progressing. But as I said earlier, it's important that you can show us that you do appreciate what the profession actually looks like. We've had another question, Rebecca, perhaps I can pass this on to you. How does a barrister keep themselves motivated when they primarily represent employers or landlords?
It's not that hard, actually. Things are very, very rarely black and white, especially in the employment context. Just because you're acting for the employer doesn't mean you're acting for the big bad baddie. At the moment, I'm in the middle of a very complex case, but the allegations against the claimant involved some quite unpleasant racist social media posts. So that's the allegation. Motivation, I suppose it comes down to two things. firstly, you don't really align with your clients. One of the great things about the bar is that you represent without fear or favour. And some of you may have seen in the news the Times article about Diana Rose KC that has caused a big hoo-ha about her representing the Cayman Islands about same-sex marriages. So your client not always so important as you might think, but the thing that motivates you really is being very skilled at your job and doing a great job in an interesting area of law with fun advocacy and cross-examination, whichever side you're on. So I think that's my answer.
Thank you, Rebecca. Eleanor, perhaps I can direct this question to you. What's the relationship like between clerks and barristers?
There are two Eleanors, so I'm going to jump in and assume it was me. It's brilliant at 42, certainly in my experience, and I'm part of a really lovely group for more junior tenants, and I have never heard anyone have a bad word to say about any of the clerks. It's such an important relationship. We rely on the clerks so heavily to run our diaries, to make sure that we don't have clashes, to make sure we're in the right place at the right time. And they provide us with an enormous amount of support. There's stuff going on behind the scenes that we wouldn't even begin to contemplate in terms of the admin that's involved in running our lives effectively. And they really help us out with that. One thing that's specific to me, for example, it might not be relevant to lots of other people, but certainly I've found really helpful recently. I'm about to go on maternity leave, and the clerks have been so supportive in planning the way that my career is going to look after I've had a baby and just before. So I recognise that it's one of the most important relationships that we have as barristers. And as long as you're always communicative with them and friendly and keep an open mind about things that they ask you to do, which perhaps wouldn't have occurred to you to do, but might help them out, then it's really plain sailing and it's a wonderful relationship to have.
Thank you. We have a few more minutes before we need to bring this session to a close. So if you do have any last questions, then you have a short period in which to send them to us. So please do that if you have any. Had another question just coming from a non-Russell Group university, put students applicants at a disadvantage. The very simple answer is we don't have a list of universities that we are looking for applicants from. We are keen to look at an application holistically. So we will look at how you have fared in your academic career, but obviously, as I said earlier, we will also be looking at your skills, your experiences, and that's a package really. So the simple answer to your question is no, because at the end of the day, we are looking at the entire application. Where you have studied at university is not going to disadvantage you per se. Clearly, of course, this is a career that requires a significant element of academic rigor. So we are looking for candidates who have clearly excelled during their academic career, but we don't have, as I say, any sort of list that we require applicants to have come from particular universities. All right, I don't think that we have any last minute questions. You literally have 10 seconds to send them to us if you do. But in that time, can I first of all take this opportunity to thank all of you for attending this session. I hope that you found it useful. I look forward to reading lots of applications from all of you. Can I also thank our panelists? It's been great to have all of you here, and I'm sure that our guests have enjoyed hearing the wide experiences that you have. If anyone has any other questions for the panel, then please do contact Chambers, and I'm sure that we will try and assist as much as we can. Thank you very much, everybody. Good evening.